I would state that's premature, Judge, because I haven't heard anything yet, but it's
really, I know it's up to me, but why would that be premature if they're to the victim's number, regardless of the contact?
Forbes did. Who was this guy?
outside.
Are you?
Does he need the hearing things?
Yes.
Okay,
Mr. Dabney, you need the hearing thing, that you need some assistance on that? Okay, they won't fit over that hat you're inappropriately wearing in my courtroom. There we go.
Nice hat though. I do like.
Slide it.
Okay.
Wherever you like, put it down there.
Oh, who is this?
So put it down here so you can like to see.
There we go.
Good morning again, Your Honor. Odetella, Assistant Public Defender on behalf of Mr. Forbes Dabney.
Okay. Who am I talking to?
Not entirely sure, but it would be me.
And your name is?
It's right there in bold letters in the front.
I see a judge and a period, a J and a period.
Yes.
I don't know your name.
It's all there.
Okay, that's all there.
Yes, that's all there. Your Honor, today's the date and time set for, I believe, competency.
So this is a special hearing, right?
Yes.
I come here for what they call that thing judge jury thing. That's today?
Today is the competency on your case.
I didn't ask for that. I asked for a judge.
There's a
Or
judge
jury.
today. There's a judge today present.
Got one.
We got one
To
today.
do a jury, what is that the thing called, a judge? I had a stroke.
Yes, sir, Mr. Dabney.
So I have names.
Let me help you out here. You're very welcome, sir.
I come for a jury. What do they call that? A thing when they got a
A trial.
trial,
Yes.
attorney by trial, attorney by trial?
We're going to get through this today,
I thought that was today.
not today.
Why not?
That's another part of the process. Okay. We're going to help get
I
through
just
this.
I just need to get the process going with the who the guys, the police officers.
There are police officers, there's a judge.
Are they
there
gonna be here?
attorneys. I don't believe they're here today. Okay.
Mr. Dabney?
We get them named in?
We're going to try to get them there. We're going to do a lot of stuff in your case. Okay. But today is for competency. Okay.
I don't need that.
Yeah.
Well, the judge is going to help us figure that out.
Yeah.
Okay.
Hi,
Hi. You good?
your first name is? Okay.
Well,
What's going on?
it kind of is.
What's going on?
What's going on?
Yes.
Well, we're waiting on a report on your case. We don't have it.
What, you said again, a report?
A report on your case regarding competency, so that then once we get that, we hopefully can move the case along.
Okay, then we're gonna do that at a different time?
We're going to do it at a different time.
Well, can we move?
Pardon?
Can we move
Can we move
to another time?
to another day?
Yes,
I'd be more than happy to.
thank you.
All right, so here's what I'm going to do. I'm going to adjourn this competency hearing. 1 month out is what, the 18th, 19th,
20th.
20th, June.
Yes.
So I'll move the competency hearing to June 20th, 2024 at 9 a.m. Okay?
Thank you.
You're welcome, Mr. Depp.
I did not ask for that.
You didn't ask for what?
Whatever you got there, right there. What is this thing you're getting ready to do? I didn't sign up for that.
Oh, I know, but yes, you did.
Oh, yes.
Yeah, no, okay. I signed you up for it.
You signed me up.
Yep, I did.
By what case number?
By what case number? This case number.
Oh, okay.
Okay,
Yeah.
Okay.
Move on.
yeah,
We'll
we'll
talk
move on.
about it outside, Mr. Deb.
All right.
Okay.
Fine,
You wanna take
continue.
that for you?
Hmm?
Do you want to take this for you?
Take it, please.
Yes, sir. All right. There you go. Thank you, Mr.
Thank you, Mr. Debbie. Have a
Thank
great
you
day.
kindly, Judge. Appreciate that.
Yeah, put the hat back on. All right, go ahead. What are we doing?
And I do believe that there is a bond violation that needs to be addressed, as well as I need to address the defendant's phone privileges.
Yes, Your Honor, that is our understanding. Go ahead, Ms. Barossa.
Your Honor, are you in receipt of?
I have the police report. But yes, go ahead.
I am extremely concerned as to the tamper from May 12th with the defendant's tether. But I am.
Now the tone of the entire hearing shifts. What started as confusion suddenly becomes serious. The prosecution lays out repeated contact with the victim, despite a clear no-contact order. And this is critical. It doesn't matter what was said in those calls. The act of calling alone is already a violation. In legal terms, that's a direct breach of bond conditions. And when violations happen multiple times like this, judges don't see it as a mistake. They see a pattern. So the real question is, at what point does the court stop giving chances?
Also concerned because that is exacerbated by the fact that after the defendant was taken back into custody, he called the victim no less than 8 times to her direct number from his own PIN. I have not had an opportunity to listen to those calls. I did make Mr. Ovitella aware of those calls, and I have made a request for those calls to be released to him so that he could hear them. I did receive a note from Ms. Zenda that she had an opportunity to listen to some of those calls, and it is a lot of conversation about the tether, not charging it, not understanding what's going on, and the victim asking why this was happening and why he did this to her. At this point, he was taken into custody after an arraignment, after a bond violation, after he was well aware of the no contact and continued to contact. And I think at this point, his bond currently being set at $5,000 with a 10% privilege is grossly inappropriate.
That's not where it is right now. It's been denied, but yeah, but go ahead. Anything you want to say? But let me just make sure the phone calls occurred after he was brought in for the bond violation. There were more phone calls.
From May 12th at 8:24, May
Got it.
12th at 13:50, May 12th at 13:59, May 12th at 18:45, May 12th at 18:54, May 13th at 15:15, May 14th at 18:17, and May 14th at 19:58. I did not check again after probably about 2 p.m. yesterday, so there could have been more, but as of yesterday at about 2 p.m., that was the last tally that I had.
It does sound impressive, Your Honor, but I have not heard the phone calls or anything of that nature. And until I do, I'm not able to address them at this time. So I would ask for an adjournment on that until we can, until I can hear them and we can address them.
This is his probable cause also today. Emily,
Yes,
this is his probable cause and bond violation.
correct.
Well, during the bond violation as well as the probable cause, May 23rd, 2024, 9 a.m. Bond at this time, given everything that I've seen, his bond is revoked.
Can we revoke his phone privileges as well?
I would state that's premature, Judge, because I haven't heard anything yet, but it's
Really? I know it's up to me, but why would that be premature if they're to the victim's number?
Yeah.
Regardless of the contact,
I leave it to the court, Your Honor. I'm just advocating for the client.
Defendant phone privileges are revoked pending the hearing. Thank you.
Thank you kindly.
While they do that, ma'am, what's your name? in the back? You have a case here today? All right, I just wanted to just say thank you because you could have sat there and not done anything, but you're getting up and helping that gentleman get himself out the door. I do appreciate it and it was noticed. Your name, sir?
Oh, Donald Wissett.
Thank you.
Can I say something? I'm sorry, I'm just,
No, if you want, but you have an attorney there to speak for you. I don't know.
okay, but I know, I'm saying I do.
Why don't I speak first? We've been working on a resolution, and that is for a misdemeanor. There were some charges that were coming up potentially on a 14B, and with that, we were working to try and still resolve it. I understand that there's a new potential charge that occurred about 3 weeks ago while Mr. Whitsett was in custody. That's being reviewed by the prosecutor's office. They've asked for a short adjournment to review that report to see whether or not they're going to authorize charges. There may still be an offer of a misdemeanor on the table. The prosecutor's asking for 2 weeks to be able to come.
Look at the whole picture.
Had at that time.
You know, it would be a joint request.
right.
I'm not
Yep, yeah,
specifically asking for, because if that's a new felony, will it revoke the misdemeanor offer that had previously been contemplated? Probably yes. If it gets denied, then we can resume the course that we were heading towards. But I can't ignore the fact that apparently he's been engaged in criminal activity in the last few weeks.
Can I say something?
Okay, but sir, I want to make sure that you don't say anything.
This part highlights something a lot of defendants don't realize: talking too much can hurt your own case. The judge is actively trying to protect the defendant from self-incrimination, but the defendant keeps explaining. Emotionally, it makes sense he's frustrated, he wants to be heard. But legally, it's risky. Anything said in court can be used later. This is why lawyers always say, let your attorney speak. So ask yourself, if you were in that position, would you stay quiet or try to explain everything?
About what they're looking at or anything about any charges. Okay, I don't want you to say anything that may hurt you.
So you're saying I'm saying about the charge?
You shouldn't be talking about the charge.
Okay, Judge Simpson. They said, okay, I'm talking about the other one. Okay, like when they said the first one about this larceny, it ain't came up. And they've been turning 8 weeks. I got a newborn baby.
Hold on.
Easter.
The larceny?
Yeah, they said it was one popped up. It wasn't one because and they said they was kept adjourning for it. Now it's talking about this other case. And it's nothing. I don't even know see why he had a paper he came to show me yesterday. It was a job count 1, and I plead to usage for the judge.
Right, but did you listen to what was just said? There's some activity. I don't know what it is, and I don't want to hear even your version of it. But there's some activity that occurred that may be criminal activity that occurred while you were in custody. That's been sent to the prosecutor's office to review to see if there will be additional charges. You follow that?
Yeah.
They're making that decision, okay, about whether or not new charges will come. What I guess you're explaining to me about the plea offer and what Mr. Drukas would have explained to you was indeed the plea offer, but now this other criminal activity may change the prosecutor's position as to whether or not you could do that. So what your counsel is jointly requesting with the prosecutor's office, and I think it's a smart thing to do, but you might disagree, is to adjourn it out a couple weeks, figure out what they're going to do. If they authorize charges, that misdemeanor plea may not be in play anymore. If they deny it, then the misdemeanor plea and what you talked about, you can go ahead with.
Okay, but I've been here 8 weeks. I got all these kids with her, and then she had another baby on Easter, and I've just been in here. And I got my parole. I was talking to my parole the other day. She took up the charge. Like I don't see how I'm still in here. He's talking about the felony. There's no felony got to pop up.
Well, I don't know that.
Because if I get assaulted and I
don't want you saying,
okay.
Okay. I mean, I don't want you saying anything about a case that may be coming up against you because that can be held against you. Okay. That's the reason I don't want you to say it. All right.
All right.
I would ask for 2 weeks for a new. You want to address?
Probable cause conference, May 30th. Is that right?
Yes.
2024, 9 a.m. Bond continue.
Your Honor, he wants me to address bond. I know we
Go
addressed
ahead.
bond here last time. If the court would allow him out, would go to community corrections and test. I think the last time that we addressed bond, it was the fact that he didn't show up last year.
Correct.
He has been in custody for a period of time. He has sobered up. And asking to be able to test a community correction.
And I let him out. He doesn't show, he was gone.
And
For all that
he
time.
would not object to a GPS tethering.
Not doing that. I denied it previously. I don't see anything that's changed. Motion for bond reduction tonight.
Thank you.
Judge,
What?
good afternoon, Robert J. Cole on behalf of Wardell
What
Smith.
did he say?
Judge,
No, no,
what?
can't come up here.
That's fine.
You're looking to cut, I know what you're trying to do because you're starting to walk there.
Judge, Judge, I called Wardell. He's stuck in traffic, but he promises 10 minutes. Can you please pass? You are the most considerate, gracious. I know, so I'm sure you won't object.
Wardell ain't in traffic.
Thank you, Judge.
From where?
Well, he just said he's 10.
From Ipsy?
Judge, have you gone down Washington Avenue lately?
Yes.
Oh, you come here early because you're such the judge type, you get here early all the time.
The judge type? I don't know what that, fine, kill it all, I'll pass it. You worn me down. He wasn't leaving the podium till he got that. Uh-oh.
Good afternoon, Your Honor. Nikki Berger, requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of the most punctual attorney, Jay Ballinger, representing Mr. Pate, who is present.
Wow. I almost want to deny it because that's not true. Where are you from, young lady?
I'm originally from California, but I'm attending law school at Michigan State.
Where?
Michigan State, go green.
Why? Brown, you need to talk to her. Come in here, spell terrapin really fast. You can't do it. You're
They didn't
a
teach us that
Spartan.
yet.
You're a Spartan. Anything longer than 7 letters, you can't get. All right. I guess permission to practice is granted.
Thank you. Please state your name for the record.
Robert Pate.
Thank you.
We are seeking adjournment for 2 weeks out to discuss the potential for
Is that written all down there?
it is
Okay, go ahead.
okay. For for a global resolution.
Your Honor, no objection, and for the record, we had a discussion before we got here. She was very worried that I wouldn't be kind to her. We had
What?
no idea.
What? Oh, that you wouldn't be kind to her? I was kind. Hey, Emily, was I kind? Okay. Glad you all jumped on my bandwagon. Probable cause conference, May 30th, 2024, 9 a.m. And will continue. Thank you. Thank you, sir.
Thank you, Your Honor.
Michigan State. I didn't even know they had a law school. Brown, I don't know how you let anybody get up here and say go green anything. No. We'll talk. I'll send you an email.
So a notice to quit was sent to Ms. Marshall for lease violations on March 14th, giving her until May 1st to vacate, and plaintiff does not yet have possession of this unit.
Ms. Marshall, did you get that information?
What information are we talking about? I got a bunch of stuff. I got a bunch of papers and I read them as best I could, and I didn't read them all.
Okay. All right. Are you planning on getting somebody to kind of help you with this?
Yes, sir, I am.
Go
I'm
ahead.
just waiting on them. Oh, thanks so much.
Welcome.
That's nice of you.
Oh.
Thank you.
Okay, who were you waiting on?
Some friends, they're busy and, I'm waiting on them to help me out.
Okay, your friends, how were they gonna help you?
Well,
You
return the items that I have in my apartment to the people that, should have them back. And, to, clean the carpet. I've tried to clean the carpet, best I can. And it's not working out too good, so I've got some more cleaner. And I have a trouble, bending over, but I've tried to clean the carpet as best I can. And I'm depending on them to clean the rest of the carpet.
Okay. All right. But let me ask you, do you have these folks all lined up or already, or we don't know when
Yeah,
they're coming?
I have everything set, in, item order for each person, so each person can get their stuff back. I started going through my stuff and found out that I had stuff in my apartment that belonged to other people. And, I'm trying to get it across to them. Please, pretty please, Dan, please, 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 come and get your stuff so I can get this apartment cleaned up.
Okay. All right. Mm,
Have you got anybody that you know could get, eye to eye with my friends and say, hurry up and come and get my stuff?
well, no, I don't know. I
Have
don't
you
know
got
that I
any
can do that.
extra time? It's coming up the weekend, sir.
Pardon?
I say, sir, have you got any extra time? The weekend's
right.
coming up, and if you know of anybody that you can look face to face for me and say, get a shake on the leg here and get this stuff out of here.
Your Honor,
Okay. Here.
Your Honor,
Yes, sir.
Miss
Go
Marshall's
ahead.
under the impression if she cleans the apartment, she can stay there. I don't think she fully understands that she's being evicted, and if she cleans the carpet, that doesn't matter. She's under the impression if she cleans the apartment, she's staying there.
Well,
So
hold on,
she
let me
doesn't
find
fully
out.
understand what's going on right now.
Well, I'm trying to pay my rent, but I can't. I keep getting stuck back coming to here, and my rent is late, and I'm trying to get my rent paid up, and I keep getting pulled back here, so I can't get it paid, and it's late for this month.
Your Honor, plaintiff has blocked rent payment to avoid a park forest defense.
Yeah, I
I
understand that part.
talk with my client to see if this is a case where they'd be willing to enter into a conditional order of dismissal that allow Ms. Marshall to stay, or if they want, this to result in a move out. I have to confirm that with my client.
Okay. All right.
And
All right, Marshall, here's what I'm gonna do. You got folks with you. Have you tried to contact Legal Services of South Central Michigan?
No, I was understanding that I'm supposed to do it later.
Okay.
So
Here's
Your
what I
Honor,
want you to. Yes.
I've been talking with Toy Dennis, and Toy Dennis told me once she's served with an actual hearing date that they will work with Miss Marshall for legal services, but Miss Dennis would not start until she had the actual date. And we were provided with this hearing date yesterday afternoon around 2:00. So we just knew about this hearing yesterday at 2:00, and I called Miss Dennis to let her know, and I have not been able to contact Miss Dennis. I was not able to get in contact with Miss Dennis yesterday afternoon, but I have talked to Miss Marshall that, once she does have the hearing date set, she can work with Miss Dennis, and I have talked to her about that. But the problem is right now, Miss Marshall has been at Brightwell and East Lansing. She was there for a couple weeks and she was discharged back home. CMH petitioned her, and now she's back at Brightwell. So I don't know how that's going to work with Miss Dennis and Miss Marshall, since Miss Marshall is out of the county.
Got it. Okay, so let's do this. Since Legal Services has been contacted, I'm going to give you a date to come back 1 week out to May 24th, 2024 at 1 p.m. And so you can let Miss Dennis know that that's the date I've set.
Okay.
And it may be, and that she should probably get in touch with the Fink Law Office for the plaintiff, get a clarification as to whether or not this is a circumstance that can be corrected or whether or not they want to move out. I think that's going to be the first thing that's going to have to be answered.
And
And then try to tie it.
I did talk to Carpenter Place. You know, we do have the $1,000 in funding, and I told them I can pay someone to clean the carpet and do all that, but they said it was kind of irrelevant at this point because they want her evicted. So they kind of told me to save my money, don't spend any money to clean this apartment.
Okay. So,
Your Honor.
all right. Well,
Your Honor.
we'll have plaintiff's attorney check that and double check it just to make sure.
Yep.
Your Honor. Miss.
Yes, ma'am.
Your, excuse me, Claudia was cleared for discharge yesterday. And so we were planning to, she was cleared yesterday before we found out about the hearing date. Our plan was to discharge her back to her apartment. If she leaves tomorrow or Monday, can she return until the next court hearing?
You mean, can she go back
return
to the
home?
apartment?
Mm-hmm, yes.
Yeah, the apartment is hers until such time as the court says otherwise.
Okay, thank
Can I-
you.
Sir?
Yes, ma'am.
If I can get out of here today, it's Friday. I can get to the bank and get a certified check, which I always give for my rent. I want to get, sir, I really want to get my rent up to date. It's almost in for another month, sir. And if I can get out of here today in a reasonable time, I want to get to the bank and get the late fees paid because it's real important to me. Okay, I don't want to take up your time, and I'm thanking you for listening to me.
No, not a problem. Okay, Miss Marshall, do this, okay? Do this for me with your rent. Just hold on to it and we'll figure out next week what we're gonna do with that, okay?
Oh, okay.
Okay,
Next
so
week, almost time for another rent pay.
I know, but you just do that. You're not gonna be in any trouble. Okay,
If you say so, sir, you have got it.
Okay, all right. So we'll talk about that next week.
Thank you.
And just for Ms. Marshall, we're not, your landlord is not assessing late fees while your rent is blocked. They're not going to charge late fees. They blocked it on purpose because there's a court case pending.
Oh.
And so they're not going to be charging late fees while that's blocked.
Oh, okay. Thank you.
And then, Your Honor, I was just going to ask if Lori could put her email address in the messaging thing so I can contact Lori of how to get in contact with Toy Dennis.
So I am not sure how to do that. I can call you with it because I work with Elizabeth and Jeannie.
Okay, perfect.
At Brightwell.
Thank you so much.
Yep, I'll call you with it.
All right. Thank you, folks.
Thank you.
See you next week.
Thank you, and thank you. I don't know how to thank you more than thank you.
Thank you, Ms. Marshall.
I'm not reinfecting myself.
Thank you, Your Honor.
Thank you.
This entire hearing shows how quickly things can escalate inside a courtroom. What begins as confusion about procedure turns into serious consequences due to repeated violations, poor decisions, and lack of understanding of the system. The judge's role here is clear: maintain order, protect all parties, and enforce the law consistently. And the biggest takeaway: actions outside the courtroom can completely change what happens inside it. If you found this case as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.